Doing nothing. Elder law and estate planning ensure you and your loved ones are taken care of by addressing what happens when you decline, how you want to be cared for, and how your wealth should be distributed after you're gone. Hi, this is David, an elder law and estate planning attorney in DC. In this video, we will introduce the various estate planning tools, including having a will, doing nothing, joint ownership, giving assets away, beneficiary transfers, and revocable living trust. Then we will jump right into what happens if you do nothing, relying on the government's one-size-fits-all plan known as intestacy law. We'll explore the implications of dying, intestate, the potential for guardianship and probate proceedings, and the often surprising results of intestacy law, especially regarding what your spouse and children might inherit. By the end of this video, you'll understand why proactive estate planning is crucial to avoid unintended and potentially unfair outcomes. Let's get started.
Today, we're going to talk about various estate plans, having a will, doing nothing, joint ownership, giving assets away, beneficiary transfers, which are transfers on death, and a revocable living trust. Doing nothing. Well, how is that an estate plan? That is an estate plan, which is that the government has an estate plan for you, which is one size fits all, and it's called intestacy law. And so when you die and you haven't done anything, then you're referred to as dying intestate. And that process is what we call probate. And anything that occurs in that process will be governed by DC law or Maryland law or Virginia law. Doing nothing also can result in a guardianship. If you do not have like a durable power of attorney or a revocable trust, then you can ultimately end up in a guardianship. So at death, you do nothing, then you have a probate proceeding. If you become incapacitated or decline while you're alive, then that's a guardianship proceeding or intervention proceeding. I'd like to talk about this to example of what does my spouse get under intestacy law, because I think it leads hopefully to the same conclusion for you that it did for me, that one size does not fit all. It, in my opinion, most of the times results in a very bizarre result. So I like to go through this example and say, what does my spouse get? So if I have no kids and my parents do not survive me, then my spouse will get the entire estate. That seems pretty reasonable and is what I would expect. If I have no kids, but a parent or both my parents survive me, then my spouse will get 3/4 of my estate, and my parent or parents will get 1/4 of my estate. Now, to me, that is a bizarre result that I would not expect my parents to ever inherit at the expense of my spouse. So, just keep that in mind. The next one is kids with my spouse. If I have kids and my kids are also my spouse's kids, I would expect that my spouse would get the entire estate, and then my kids would inherit from my spouse. But the reality is no. If my kids are also my spouse's kids, my spouse is going to get 2/3 of my estate, and my children will get 1/3 of the estate. And then finally, this one kind of makes sense to me. If I have kids, but my current spouse is not the parent to my kids, then my current spouse will get 1/2 of my estate, and my children will get the other half of my estate. And I guess, out of fairness, that one probably makes the most sense. If I die without a will, my spouse will inherit everything. Then at my spouse's death, it will go to my children. And that, as I just finished saying, is false. That is not what will happen. I think most of us would indeed expect that to happen if we didn't realize that we're probably doing a question that an estate planner is providing us as a trick question. We probably would have answered that true.